Hello, my name is Ashley Ellickson, and I'm continuing our discussion on agriculture water law with a discussion on drainage law today, and this is part 4 of our 4-part series. So again, we're going to look at drainage law in Maryland. The general rule for liability related to stormwater runoff or drainage is referred to as the civil rule. Higher elevation landowners have the right to have surface water flow naturally over the lands of a lower elevation landowner, and the lower elevation owner has no right to prevent that flow. Lower elevation landowners cannot install other features to dam the natural flow of water over their property, while higher elevation landowners have the right to have water flow off their properties onto lower properties. These landowners are not permitted to increase either the amount or volume of water flowing onto lower lands, causing damage or injury. For example, higher elevation landowners cannot channel water onto lower elevated properties in a way that causes damage to those lower properties. The application of the civil rule can have harsh results. In Maryland, courts have adopted a qualification to it known as the reasonable of use test. This involves an analysis of the balance of benefit to the higher elevation landowner versus the harm to the lower elevation landowner so that the lower elevation owner is not unreasonably denied use of his property. The reasonableness of use test does not replace the civil rule, but rather allows courts to incorporate conditions into a judicial decision to reduce harm caused to a lower elevation property when the higher elevation landowner is acting in an unreasonable way. The reasonableness of use test has resulted in Maryland courts finding higher elevation landowners to be in the wrong for 5 of the following reasons. The first, increasing materially the quantity or volume of water discharged onto the lower land. 2, discharging water in an artificial channel or in a different manner than the usual and ordinary natural course of drainage. 3, putting upon the lower land water owner that would not have flowed there if the natural drainage conditions had not been disturbed. 4, causing dirt, debris, and pollutants to be discharged onto the lower land. Or, lastly, otherwise creating a health hazard. So these are the 5 instances where courts have found higher elevation landowners in the wrong. So what can a landowner do to stop damaging runoff? Communicate. Communication with your neighboring property owners are vital in these situations. If a lower elevation landowner is able to communicate with a higher elevation landowner, the drainage issues may be able to be resolved in a mutually agreeable way before damage is done or a court case occurs. That's what we're going to get into now. So a civil lawsuit for trespass, nuisance, and or negligence to stop the harmful drainage and to get financial damages to compensate the person for injury to their property can be filed. And this is where communication can help deter the lawsuit from coming about. And that is going to take time and money, which all of us do not even want to start to get into. However, if a lawsuit does arise, it's going to be very difficult to prove this damage. Why? Many of us don't walk around our properties and take photos of what looks like a perfectly normal state of our property. So how can you prove that damage has actually been done by that higher landowner? Well, this is where you're going to want to walk outside and take photos of that naturally occurring state of your property. So if this were to occur, a lawsuit is to come up, you have proof that damage was actually done. So document your property conditions. Thank you for listening to this presentation today. Again, my name is Ashley Ellickson. My email is aellix@umd.edu. And my colleague Sarah Everhart is severhart@law.umaryland.edu. Both of our phone numbers are also displayed on this slide, so please feel free to reach out to us if you have any questions. Thank you.